This law school has achieved an enormous amount in its relatively brief life, and judging from the quality of the staff and the students that I've seen already upon my return here, it will contribute a great deal more to the life of this country for many decades, and I hope indeed for centuries to come. Now, self-indulgence is an affliction to which lawyers are especially prone, and probably many of you, even as we speak, are being trained in self-indulgence, and semi-retired judges are not immune from this affliction. But now that I've got a captive audience, I don't think there's a door that can be shut, but let us assume that there is a notional door that has been shut and you can't get away. I formed the view that self-indulgence has a good deal to commend it. So what I'm going to do is have some introductory reminiscences before I turn to the very long reminiscences. I first set foot on this campus in 1971 for what turned out to be a rather stage-managed interview for the position of Professor of Law. I don't think they do things like that anymore. I did so not long after the institution had been converted from its status as a university of technology to a real university, earnestly striving for recognition through respectable faculties like medicine and law. The law school at that stage, 71, was in its first year of teaching, but of course it was more of an intellectual construct than a physical presence. The staff were housed in the now extinct huts of sacred memory, located not too far from the impressive high-tech building that has been erected in recent times. There's an old hut. That was the library, and the rest of them look like that. Now, in order to appreciate the gulf in time between 1971 and now, let me remind you that that was the year that Billy McMahon ousted John Gorton in a Liberal Party coup to take over as the last Liberal Prime Minister in the Conservative ascendancy that had commenced in 1949 and continued until the following year. Gough Whitlam wouldn't be elected Prime Minister of this country until 1972, the following year. The Vietnam War hadn't ended. The Family Law Act, which introduced no-fault divorce, hadn't been enacted, nor had the Trade Practices Act, which worked a revolution in the protection of consumers and in the conduct of commerce, and the great administrative law reforms, federal administrative law reforms of the mid-1970s were still half a decade away. So it's a long, long time ago. I won't belabour the comparisons any further, except by reference to my position as a dean, to which David just referred. A modern dean of the Faculty of Law has to combine the learning of Sir Owen Dixon, the great Chief Justice of the High Court, but without his irretrievably gloomy outlook on life that you can discover by reading Philip Ayres' biography, the creative and majestic clarity of expression of Lord Denning, who lived, of course, to be over 100, but his longevity is an optional extra for the Dean. The profundity of Julius Stone, whose portrait hangs on level 3, and I hope Margaret, his daughter-in-law, will forgive me, but perhaps a profundity supported by slightly shorter footnotes. You need the resource accumulation skills of Gina Reinhardt, but preferably without the intra-family litigation. And you certainly need the political skills of R.J. Hawke, including, above all, his ability to choose his biographer carefully, but he had to marry her. Now, my day, apart from bare literacy, the major requirements of the Dean were the ability to add and subtract the figures supplied by an all-powerful central office and the stamina to sit through interminable and indecisive meetings, most of which, as I seem to recall, dealt with a curriculum and whether it should be reformed and whether it was unduly elitist to have an honours degree. And I noticed from the various illuminated signs that I see about this high-tech or the high-tech building down there that the curriculum has finally, after 40 years, been reformed. As someone once remarked about law reform, why were these reforms necessary? Weren't things bad enough already? If you wanted to see what a dean looked like, oh, just a minute. That's what a dean looked like in 1979. And as you will see, there has been no change whatsoever. All right, now I'm going to turn to the really long part. If one is going to discuss whether and when law and justice intersect, it's necessary to have some idea of what those terms mean, and that's not a very straightforward exercise. After all, generations of philosophers, legal and otherwise, have devoted themselves to that task. I want to concentrate on a personal view of justice and what I see as its counterpart, which is the elimination of injustice. So I'm not going to say very much about law. I will content myself with offering that as a very standard orthodox definition, and you don't really need to absorb it anyway because it doesn't really matter for the purposes I have tonight. But let me say something about lawyers and the concept of justice. As you know, philosophers have been pondering the concept of justice over thousands of years. In the Western tradition, the meaning of justice goes back to the Old Testament, to Aristotle and beyond. And other cultures as well have been no less assiduous in the search for the meaning of justice and have done so over similar time spans. An example is the Sanskrit literature on ethics and jurisprudence. So there's certainly nothing new about the issue. Many profound thinkers, ancient and modern, have confronted the task of formulating objective standards by which to determine whether a society can be regarded as just or whether particular conduct is just or virtuous. The best known effort in recent times is that of John Rawls, and his two principles of justice, which appear at the bottom, are those from which he derives a great deal else in his philosophy of justice. He takes those two principles from what he describes as the original position, a summary of which is provided by Amartya Sen in the extract that appears up the top. Again, you don't need to follow the intricacies of Rawls's theory. My purpose in referring to it is not to add to the literature, which I'm not equipped to do, but only to illustrate the vibrancy and to some extent the indeterminateness of the continuing philosophical quest to define authoritatively the content of a word that pervades our daily discourse as lawyers. Lawyers are much concerned with justice. Unlike most other professions, the notion of justice is central to what we do, or at least what we claim to do. This is demonstrated by the language of the law, which is replete with references to justice. We speak, for example, of the justice system and the administration of justice. In Australia's system of government, those who wield judicial power are given the title justice. Enhancing access to justice is universally embraced as an essential objective of the legal system and of the work that lawyers perform within that system. To label a decision, for example, of a court as unjust is to condemn it as contravening fundamental societal values and to go some way towards depriving it of legitimacy. Despite the training of lawyers and despite the centrality of justice to legal discourse, the reality is that lawyers, and they're not really very different from other people in this respect, lawyers don't really regard themselves as legal philosophers, most of them, and nor, I suspect, would they claim that their professional lives have been shaped by a particular theory of justice, whether it be Rawls's or anybody else. It's true that lawyers are required to familiarise themselves with and to observe complex and sometimes counterintuitive ethical rules that are designed to promote justice, protect clients, advance the rule of law. But like the ethical standards that bind all members of professional groups, they're external standards and they're really imposed upon practitioners, and for that matter judges, as the price for plying their trade and belonging to a profession that is recognised as having special skills and expertise and that enjoys a monopoly on certain kinds of work. It is true that many lawyers, although regrettably perhaps not a high proportion of lawyers, devote themselves, often at great personal cost, to protecting the rights and interests of poor and other vulnerable people. Other lawyers see their role as primarily to resist the incursions of state power into the freedoms and liberties of individuals, notwithstanding that in order to do that they represent clients who may be distinctly unpopular, unsavoury, or both. Lawyers who take on these burdensome tasks are undoubtedly motivated by a belief that they can use the law and legal processes to advance justice, or at least to minimise injustice. But I suspect again that most wouldn't say that their professional choices, admirable as they are, reflect a philosophical inquiry into the nature of justice as distinct from deeply felt personal views as to what is right and proper and how their professional activities can contribute to a more just society. The two categories are not mutually exclusive, but I think the distinction is there nonetheless. A person's own concept of justice, everybody in this room's concept of justice, will be influenced by a great range of factors. I'm going to talk about the influences on me, or at least some of them, because I know them best. I don't propose to disentangle all of those influences, but I want to recount something of my own background and a couple of personal experiences for two reasons. First, I think that personal experiences tend to have a lasting influence on the social attitudes of the people who've had those experiences, including one's own conception of justice. And secondly, my experiences, which of course would not be unique, illustrate just how profoundly this country has changed, largely for the better, over the nearly 5 decades of my professional life. I grew up in a moderately observant Jewish household in Melbourne. Of all the countries in the post-World War II world, outside Israel following its creation in 1948, and the United States, Australia was the most welcoming to Jews, at least those Jews who were already there. Jews had been part of the Australian community since the First Fleet, although not initially as a matter of free choice. The small Australian Jewish community had played a prominent part in the nation's affairs almost from the beginning of European settlement, and the community had certainly provided more than its fair share of leaders. 2 examples will suffice. The one on the left is Monash, recognised as a national hero for his exploits on the Western Front towards the end of World War I and much else. Monash happened to be a member of the St Kilda Hebrew congregation, of which my father later became president. Monash was such a revered figure in this country that 300,000 people attended his funeral in 1931. 60,000 people were at the graveside, where the service was conducted by Rabbi Jacob Danglo, who happened to preside when I had my bar mitzvah in 1956. The second one is Sir Isaac Isaacs. You didn't know that elderly Jewish men like to dress up in funny costumes, but they do. His biographer is another Jewish Governor-General, Sir Zalman Cowen. Isaacs had been briefly Chief Justice of the High Court, and shortly before Monash's death, he became the first Australian-born Governor-General, albeit over the vehement opposition of King George V. As it happens, Isaac's father-in-law had preceded my father as a president of the St Kilda Hebrew congregation as well. St Kilda, by the way, is not a Jewish saint. St Kilda is the name of a suburb in Melbourne. It won the AFL Premiership in 1966 by 1 point on the Day of Atonement. And yet Australia, despite this history, has had a history of genteel anti-Semitism. Those 2 comments, one made by Alfred Deakin, one made by Barton, both of course later members of the High Court, both politicians, give a flavour of something that was very common in the Australian history. Isaacs himself had experienced openly anti-Semitic attacks at various times during his long life, to which, as Zalman Cowen recounts, he was prone to respond with very considerable anger. Growing up Jewish in Melbourne in the 1950s and 60s, it was impossible to avoid contradictions. On the one hand, eminent men, people, Jews like Monash and Isaacs, had played and been recognised as having played a most important part in Australia's history. Jews had flourished in an atmosphere of freedom and, for the most part, tolerance. On the other hand, the manifestations of anti-Semitism, much as one tried, couldn't be ignored. Generally, these manifestations were thoughtless rather than vicious, but anti-Semitic attitudes were entrenched in the language and in the social attitudes. And this was despite the horrors of the Holocaust, which, although fresh in the collective memory in the 1950s and 60s, curiously enough, figured very little in public discourse in the decades immediately following World War II. It figured much more prominently in the last couple of decades than it did then. So I never experienced the brutal forms of anti-Semitism that historically were characteristic of parts of Europe and in some parts of Europe, regrettably, still are, even in places without Jews. My experiences were vastly different from those of my grandparents who left Russia at the turn of the 20th century to escape the pogroms that were a regular feature of life under the Tsars. Nonetheless, I experienced sufficient anti-Semitism to understand how corrosive and dangerous prejudice of any kind can be, however genteel its expression. And in my own case, it led to a feeling as a student and a child and young man that in some respects I was an outsider, not necessarily part of the Australian mainstream, even if I played sport and even if I followed with a great passion South Melbourne Football Club, later to become the mighty Swans. I do hope to be invited to give another lecture on the Swans with particular reference to the years 1909, 1918, 1933, 2005 and 2012, and if you don't know why they're important, then go away and look it up. One experience, relatively trivial as it may seem, is seared in my memory. In 1967, I returned to the University of Melbourne, from which I had graduated, as a senior lecturer. I did so after a year studying at Yale and a second year teaching at the University of California at Berkeley, just before they burnt the place down the next year. I knew in 1967, when I was back at Melbourne, that one of the very senior academics was a member of the Melbourne Club. That club, like many others at the time, did not admit Jews. Hence the establishment in the 1950s and 1960s of Jewish golf clubs. The one in Sydney is named Monash. Being young and brash and emboldened by having observed, or having thought I observed at close quarters, the great society of President Lyndon Johnson, I raised the issue with the senior academic over a lunch. How is it consistent, I asked him, with what I understood to be his commitment to justice and equality for him to belong to a club that excluded people on the basis of religion or race? His response was that he saw no inconsistency. The club was a voluntary association and its members were entitled to determine for themselves who was eligible to join. I thought his response then, as I do now, was profoundly demeaning and unjust. And the thought occurred to me that it was not entirely coincidental that, unlike the more robust state of New South Wales, no Jewish lawyer had ever been appointed to the Supreme Court of Victoria by this time. And that was so, notwithstanding that significant numbers of Jewish lawyers and barristers in particular had been leaders of the Victorian bar, including the eminent Queen's Counsel who'd moved my own admission as a barrister and solicitor. Let me recount an anecdote on a different, but in a sense related topic. In 1956, the Olympic Games was held in Melbourne. It was a much more modest affair than the extravaganzas to which we've become accustomed, but the Games in '56 were enlivened by the efforts of the Hungarian and Russian water polo teams to drown each other, this being just a few months after the brutal Russian invasion of Hungary. Every Games has its highlight. Shortly before the Olympic Games, I was travelling on a tram in Melbourne, a mode of transport that has survived technological revolutions. And I was travelling to my school, Melbourne High School, an excellent selective boys' public school with some remarkable teachers and some equally remarkable students. At the stop, a black man boarded the tram. I suddenly realised with a shock that I had never, to my knowledge, been in the presence of a black man. Black person, not an Indigenous person, not an African American, that wasn't the descriptive term then used, not a black person from any other country. I might have seen such a person, but I was not conscious of doing so. And I'd certainly seen films or newsreels with non-Europeans. Television had been introduced in this country only a few months earlier, but this was different. My surprise was not as strange as you might think from the vantage point of the second decade of the 21st century. In 1956, the White Australia policy, one of the pillars of the Australian settlement since Federation, was still in full force. The depth of Australia's commitment to the White Australia policy and a corresponding attitude to Aboriginal people is shown in the comments made by Sir Owen Dixon in a speech he gave in Tennessee in 1943 when he was Australian Minister to the United States on leave from the High Court. That's what he said. In 1950, when he was acting as United Nations mediator in the Kashmir dispute, Dixon said that his experience showed, quote, how utterly impossible it is for us to relax the white Australian policy, unquote. This is the man who is regarded as, with some justification, as the greatest Chief Justice in Australia. It wasn't until 1957 that a concession was made allowing a non-European resident of at least 15 years standing to apply for Australian citizenship. And it wasn't until 1966 that the White Australia policy was finally jettisoned. Not long before that tram journey, my Year 9 class at Melbourne High School had engaged, I remember very clearly, in a lively debate about the merits of the White Australia policy. The incipient conservatives among the 13 to 15-year-old boys argued that Australia's immigration policy should seek to create a little Britain, embodying the best characteristics of the mother country, who, as you know, whose flag still adorns a little corner of our own flag. The incipient progressives, the minority, argued that Australia should aspire to create a little Europe, incorporating the best characteristics of European culture and history. Not one member of the class, myself included, and they were very bright young men, argued for a migration policy that would admit migrants from around the world regardless of race, national origin or religious affiliation. The class included future writers, historians, lawyers, I exclude myself, medical practitioners and others who achieved very considerable eminence. None of us, however, at that stage of our education was able to break free of the shackles that the White Australia policy had placed upon our imaginations. The lesson I drew from this episode, looking back years later, was that ingrained attitudes can be extremely difficult to displace, even, or perhaps especially, if they are founded on irrational beliefs. Martha Nussbaum, in one of her books, says much the same thing. Particularly is this the case when attitudes are inculcated from a very early age, however subtly. We are invariably quick to recognise injustice when it's inflicted on us, or on those with whom we associate or identify. We tend to be much slower in recognising injustice that affects others, even to the point when we ourselves unwittingly become, if not the perpetrators, then complicit in the infliction of injustice. Let me turn to a sense of injustice. And in doing this, I move backwards in time to, with apologies to Donald Horne, to the education of young Ronald. At the University of Melbourne in the 1960s, jurisprudence was a compulsory subject, as indeed were practically all the subjects in the undergraduate curriculum. You didn't have the astonishing choice that you have now. Jurisprudence didn't have a lot to do with theories of justice. The focus was on analytical jurisprudence and the nature and definition of law. We spent a lot of time on H.L.A. Hart and on Austin and so forth. There were detours in the direction of the American realists, although acceptance of their radical ideas was impeded by what seemed to be a lingering resentment about American impertinence in declaring independence from Britain in 1776. Of the realists, Jerome Frank's Law and the Modern Mind, published in 1930, served, at least for me, as a very powerful antidote to the apparently ordered and predictable common law world of precise legal rules to be applied to established facts in conformity with binding precedent. But it wasn't really very clear what would happen if the ordered world of positivism was to crumble, and what would replace it, other than the rather unsatisfactory variables of whether the judge had a good breakfast or hadn't quarrelled with anybody on the morning of the case. Looking back, I have to acknowledge that even if the course had included a systematic study of theories of justice, I very much doubt that my immature mind would have been able to grasp the abstract concepts. Indeed, nearly 50 years later, when I read Amartya Sen's doubts as to the practical utility of theories that seek to identify the characteristics of a perfectly just society, you can find that in Sen's book, The Idea of Justice, I felt a sense of relief. A world of theoretical perfection can illuminate reasoning and analysis, but is not necessarily of much help in making hard choices between apparently reasonable alternatives. But during my studies, I did come across a book that catered to my limited capacity for abstract analysis and also seemed to make a lot of sense. Edmund Kahn was a tax lawyer and trust lawyer who joined New York University Law School in 1946 and taught there until 1964. Oddly enough, he became a legal philosopher which is not the standard career progression for a tax lawyer, socially aware and committed to fairness, though all of them are. Like Jerome Frank, Kahn was a legal realist, and the two were close friends. Kahn published in 1949 a book called The Sense of Injustice, an anthropocentric view of law. I've got it in my bag, so in fact I've got it behind the table here. That was the book that I read. Kahn commenced with a quotation from W.H. Auden's poem, Law Like Love, the first part of that extract, which I read as a wry condemnation of an approach to law that divorces legal rules from morality or justice. He didn't quote from another passage in Auden's poem, which is the second one, which is actually very revealing about the judicial process. Kahn rejected natural law as a counterbalance to amoral positivism. That rejection was perhaps associated with his admitted inability to explain affirmatively what the word justice meant. He thought it made much more sense to talk about the sense of injustice, which he described as that general phenomenon. And he demonstrated his idea, which appealed to me because it seemed to be something that I could recognise and apply to everyday situations. He demonstrated his ideas through a number of instances or examples. His instance A concerned a hypothetical group of people, all of whom had committed precisely the same offence at the same time, but who had been treated unequally by the legal system. Some had been acquitted, some had been found guilty but given no punishment, and some had been found guilty but subjected to unaccountably severe penalties. These diverse outcomes, said Kahn, arouse a sense of injustice in us because they offend our deeply rooted belief that arbitrary inequality is the antithesis of justice. Kahn did not assert that all aspects of the sense of injustice were universal. He nonetheless thought that the concept was real with pragmatic consequences, even if it was not universally valid. To him, the sense of injustice was an active, spontaneous source of law, contributing its current to the juridical stream. Rereading The Sense of Injustice, which I did recently, it's not difficult to see flaws and gaps in Kahn's analysis. His intuition about decisions or actions that will evoke outrage or shock among the populace is convincing enough in the case of his most extreme examples, but is highly contestable elsewhere. He appears to assume a societal consensus that does not and did not exist, even in the United States, whose citizens he primarily had in mind. The discussion at Melbourne High School, to which I have referred, and Australia's confused and sometimes inhumane responses by both major political parties to the much overblown threat posed by so-called boat people demonstrate the problem. Kahn's express acknowledgement that the sense of justice or injustice is neither universal nor categorically right creates the strong impression that his interpretation of the likely emotional responses by the community to injustice reflected his particular preoccupations with the liberal sentiment of the United States in the immediate post-war years. So, is this a practical guide? Despite these and other flaws in the analysis, most of which didn't occur to me at the time, as a young lawyer I found Kahn's prescription to be an extremely useful practical guide. If legal rules, institutions and practices could be instruments that perpetuated injustice, surely it was worthwhile to identify injustices and to consider how reforms could eliminate or at least ameliorate them. The role of law in seemingly transforming the United States of the 1960s, remember that was shortly after Brown on the Board of Education in 1954, Lyndon Johnson's Great Society, the malapportionment cases and the like that the Supreme Court had decided. If law could be an instrument of oppression, surely it could also be a positive force to overcome much of the injustice associated with poverty and inequality in society. There was an element, I think, in retrospect, of over-enthusiasm or even naivety in these views, and I've written about that elsewhere. But Kahn's insight that it's much easier to recognise injustice than it is to define justice seemed to me to provide a practical reference point. Why wasn't it feasible to identify instances of institutional or systemic injustice? After all, there was no shortage of possibilities from which to choose, and to consider how reforms might eliminate or ameliorate them. Obviously, it wasn't going to be enough simply to assert that particular laws or practices were unjust. Reasoning was required, often of a technical kind, and comparative analysis helped the situation. But nonetheless, the sense of injustice seemed to be a reasonable place to start. And I did, for what it's worth. I had had experience as a very young lawyer in what were then called affiliation proceedings. These were proceedings brought by a woman, the mother of a child, where the child was born outside marriage. Often the woman had to bring the proceedings as a condition of getting what limited welfare assistance was available in those days, and she had to bring the case often in the face of the denial of paternity by the father, and in those were days before compulsory blood tests and of course before the sophistication of current DNA technology. The case in which I instructed, as it happens the barrister was Michael Black, who later became the Chief Justice of the Federal Court, brought home to me the impact on individuals of well-established common laws, particularly those that discriminated against illegitimate children solely on the basis of the circumstances of their birth, and it didn't take a lot to work out that they weren't responsible for that. And there were injustices associated with the affiliation proceedings, both of a procedural and a substantive kind. By the way, the recent apology, well-deserved apology to those women who were forced to give up their children for adoption is only part of the story. I suspect that many more women in the 50s, 60s and earlier had to give up their children for adoption because it was simply not feasible for them to support the children. The welfare provision in those days was totally inadequate for the mother and child if the child was born outside of marriage. That has not been officially recognised so far as I'm aware. So one of my co-authors and I addressed this issue in some studies dealing with the position of illegitimate children and with affiliation proceedings and with the social welfare system, and we took as our starting point that proposition that there seemed to be no rational basis whatsoever for the discrimination against so-called illegitimate children, later called ex-nuptial children. Times have changed. 4 decades on, the notion that children should be penalised for their status at birth seems to be utterly and completely absurd. The legal regime that imposed disabilities has been dismantled. Welfare entitlements no longer depend upon the circumstances of a child's birth. So at least one set of injustices has been removed. With the advent of the Whitlam government, I had the good fortune to be appointed to the Commission of Inquiry into Poverty that had actually been set up with Professor Henderson as its head by the previous government. Susan Armstrong, who's here tonight, played an enormously important role in that exercise. The theme of the report was more or less that, the failure to accord equality. I won't, in the interest of time, go through the injustices that were identified in the report. The most important of them was legal aid, or the absence thereof, in which Susan Armstrong did enormously important work that had a great impact then and in subsequent years. But we addressed many more issues, and over a period of time, all of those issues, one way or another, have been addressed. I don't say for a moment that it was the Poverty Commission that caused that to be done, but part of a process that enabled the community to recognise injustice and for remedial action of one kind or another to take place. The sense of injustice can be important in another way. Some years later, when I chaired the New South Wales Law Reform Commission, we had a reference on what were then called, still are called for that matter, de facto relationships. And we made proposals for changes in the law and explicitly put them on the basis that they were designed to overcome injustices, the most obvious of which was the case of a woman who went to live with a man. The man earned more than the woman. The man provided the money for the acquisition of the home or other assets. the woman provided a contribution to the relationship in other ways. When the relationship broke down, the result almost invariably was that the man went away with the house unless the law of trust could be invoked, and it was never a very happy fit to invoke the law of trusts because it didn't really work. And we made recommendations for a whole series of changes to the laws relating to de facto relationships. We were not concerned at the time with same-sex relationships. That would have been a step too far for a whole great variety of reasons. But as it happened, the De Facto Relationships Act, which was enacted within a year of the report, paved the way for those changes as well. We realised that one of the great obstacles to the implementation of the recommendations in the De Facto Relationships report would be the churches, who might see or religious groups more generally, who might see the recognition of de facto relationships that we proposed as a threat to the institution of marriage. We attempted to address this by emphasising the injustices and by putting to church representatives and other religious representatives that the legislation was not designed to offend their consciences but to overcome injustice. And to cut a long story short, it worked. They accepted it to their great credit, and the legislation passed without any great difficulty and became the template for similar legislation elsewhere in Australia. So far we've been talking about ways in which the law can intersect with justice, in the sense that it can provide the mechanism for ameliorating or eliminating injustice. But even identifying unjust laws or practices and explaining in detail the nature of the injustices will not provide any guarantee of reform. After all, it's hardly unknown for influential interest groups to seek to preserve their privileged status at the expense of weaker or more diffuse groups in the community. You don't need to read Machiavelli to appreciate that. But where in all of this do the courts fit? Is it the court's job to eliminate or prevent injustice? To some extent, the answer is yes. For example, one of the jobs of the court is to ascertain the facts to which the law is then applied and a decision is reached. The closer the court gets to the truth with the facts, and most cases are decided on the facts, the less likely it is that the decision will cause injustice to one of the parties, which is not to say that the losing party will necessarily accept that justice has been done. But that's not the only view of the adversary process. Another widely held view is that the adversary system is not concerned with ascertaining the truth at all. Consider this remark or remarks made by the selfsame Sir Owen Dixon when a woman was unwise enough to suggest to him that it must be wonderful to dispense justice. As he said, "I don't have anything to do with justice, madam," and he gives the reasons why that is so. Dixon's acerbic response may have been due in part to his saturnine nature, but it reflects the reality that the forensic fact-finding process is clearly not exclusively concerned with truth. At the very least, it seeks to preserve other values such as the right to a fair trial and values protected by the exclusionary rules of evidence, such as those making inadmissible relevant evidence if it infringes client legal privilege or the privilege against self-incrimination. The greater the extent to which the adversary system requires a decision maker to proceed on the basis of something other than the truth, the greater the likelihood that the decision will inflict injustice on one or more of the parties. The extent to which courts have the ability to develop the law to make it more just or less unjust or better adapted to contemporary social and economic circumstances is a very large question indeed, and I won't broach it tonight. But it's important to recognise what judges are required to do. That's the judicial oath. Notice the words, according to law. The qualification, according to law, is of profound importance. Law and justice are not the same thing. They are not coextensive. Let me just give very briefly two illustrations to make the point. The first concerns judicial review of administrative decisions. In recent years, the High Court has greatly expanded the powers of courts to review the legality of administrative decisions, both at federal level and at state level. By administrative decisions, I mean the sorts of things that occur when an applicant for a protection visa is denied such a visa by a decision of the Refugee Review Tribunal or decisions of state administrative bodies of one kind or another. There are severe restrictions on the ability of courts to correct errors made by administrative decision makers. One of the pillars of Australian administrative law is that courts are only concerned with the legality of administrative decisions. The court cannot intervene with a decision just because it appears to be mistaken on the merits or on the facts. Even if the decision lacks logic and has resulted in egregious injustice, the court cannot grant relief unless the process has been legally flawed. It's for this reason that it's not uncommon for an asylum seeker's challenge to an adverse decision by the Refugee Review Tribunal to fail, even though the court may have serious reservations, expressed or unexpressed, about the factual findings that led the tribunal to reject the application. All judges have experience with that disparity between the merits and the legality of the decision. And in a case called Hinchinbrook, dealing with an environmental case, I made that point very clear in rejecting a challenge to certain decisions that were said to be adverse to dugongs and other wildlife in the Port Hinchinbrook area. My job was to determine the legality of the decision, not its environmental wisdom. The second example I'll give is a case that I also sat on, Cabillo in the Commonwealth. That's commonly referred to as the stolen generation case. Ms Cabillo and Mr Gunner brought proceedings respectively 49 and 40 years after they alleged that they had been wrongfully taken from their families in the Northern Territory. There was no dispute that they had suffered terribly by reason of that taking. They lost before Justice O'Loughlin, and the appeal court, consisting of Justice Healy, Justice Weinberg and myself, dismissed the appeal. Essentially, they lost because the trial judge decided that it would be unjust to the Commonwealth to extend the limitation period for the extra 40-odd years that was needed in order to allow them to bring their case. We also said that there were legal reasons why, although others might have been liable, the Commonwealth itself was not liable. We were very conscious of the likelihood that the case would be used to deny the very existence of the stolen generation. And we made it quite explicit in the judgment that that's not what we were doing. We were concerned with the legality of the decision below. We were not concerned with the merits, the injustice of what had been perpetrated on these people and their families. That disclaimer did not stop those who were so inclined saying that the case was a demonstration that the stolen generation did not exist. Qualifications like that often don't have the desired effect. The point that I'm making is that there are certain kinds of injustice that cannot be remedied through the legal system, that is, through the judicial system. Other mechanisms have to be found. As Auden said in one of those extracts I put up on the screen, sometimes law is the law. You'll be relieved to know we're now at the conclusion. The question as to whether law and justice intersect is that they do and they do not. Law can be a powerful instrument of injustice, particularly in its impact on poor and vulnerable groups in the community. Yet it can also be a very powerful force for the elimination or amelioration of injustice, if it's done properly. Courts generally do strive to avoid injustice, but the overriding qualification, as I have indicated, is that they must apply the law, including the rules of evidence and the procedures for a fair trial. It's the price that must be paid for the rule of law. In conclusion, let me say this. Notwithstanding its philosophical limitations, Kahn's sense of injustice or something like it, I think, is an important counterweight to the tendency of the legal system to tolerate or even facilitate injustice. If the community's sense of injustice can be sufficiently aroused, the gateway to reforms through the political and sometimes through the judicial process can be opened. Arousal of the community's sense of injustice may require the support of influential groups, especially the media, But community attitudes are not immutable. They can be changed, and the last 5 decades demonstrates very strongly why that is so. That doesn't mean that on any given issue there's a dormant community consensus ready to be awakened. In a pluralistic and often ideologically divided society, there is not likely to be unanimity or anything like it as to whether a particular state of affairs is so unjust as to require remedial action. Even if injustice is widely acknowledged, for example, the extraordinarily and unacceptably high rates of imprisonment of young Aboriginal men, very different views may be held as to what, if anything, government should do to rectify the situation. There's no easy answer to all of this, but a good starting point, I think, is to ensure that this country has sufficient independent institutions and agencies, both public and private, whose job includes exposing injustice, not just in a particular case where an injustice might be done to someone who's been through the criminal justice system, for example, although that is important, but exposing injustice in a broader sense and proposing action to remedy the injustice. This can influence the community to understand the nature of the injustices and encourage changes in social values and therefore ultimately changes in political attitudes. Well-resourced institutions like universities that encourage independent, innovative and challenging research and teaching, as well as vigorous engagement with the wider community, have a vital role to play. But I think there are many other institutions and organisations capable of the long-term policy analysis that is so essential to the achievement of a more just, or at least less unjust, society. They include permanent statutory authorities, royal commissions, other ad hoc inquiries, law reform commissions, non-government agencies, sometimes even trade unions or industry bodies. As the attention span of the community diminishes in inverse proportion to its technological sophistication, and as the political process focuses ever more on the here and now, institutions that can stimulate the community's sense of injustice are critical to the well-being of this society. Thank you.